Good afternoon, everyone. My name is Mark Tarbox. I am the Director of TEP Education at the Eviction Defense Network, and this is a class on how to respond to discovery. And on Thursdays, we specifically cover the special interrogatories and the requests for production of documents. And so that's what we're going to focus on today. Please come to the class on Tuesday for how to respond to the form interrogatories unlawful detainer. And if you received requests for admissions, you should be contacting your attorney law clerk team for assistance with those. I'm going to share with you a response template in the chat. You can find it also on the share drive. This is a PDF version of our response template. And one is designed for responding within the deadline, preserving objections, and one is designed if you are late with your responses and you're still trying to get those responses done, you're just going to miss the deadline, either the initial deadline or if you've got an extension, the extension deadline. And it's okay to send responses after the deadline. If you miss the deadline, it's possible that even the day after the deadline, the opposing counsel can file what's called motions to compel, which will schedule a hearing for a judge to rule on that motion, which is, Your Honor, I'm compelling the defendant to respond to the discovery requests that I served them. And hopefully, by the time that hearing happens, you've completed the discovery. Sometimes the opposing counsel will take the motion to compel hearing off calendar. Other times they'll keep it on in hopes of trying to at least get you sanctioned for being late because it costs them time and therefore money to write the motion. And so we try to get your responses done on time to avoid motions to compel. We want to try to get them done as soon as possible. And so we encourage you to go to your attorney law clerk team Monday through Friday, 10 a.m. about the request for admissions. The request for admissions can do the most damage if you don't respond to them. So please don't hesitate. If you haven't started them, contact your attorney law clerk team. And I will post all of the teams in the chat. Just give me 1 second. This is for the request for admissions. If you let your team know you received discovery, they will most likely direct you to this class for the rest. And that's what we're here to help you with today. And we're going to start that in a few moments. Just want to get some of this introduction done. And so you let your team know that you have admissions. Can you get help with those? You come to class Tuesday for formal interrogatories, Thursdays for special interrogatories, requests for production of documents. And so today we're going to go over the special interrogatories. And the special interrogatories are special because they are supposed to be tailored to your case. They are questions that the attorney or the law firm for the landlord wrote for your case. Some law firms just copy and paste the same special interrogatories for all their cases. They're not supposed to do that, but they often do to reduce their time and effort in generating these. They often ask a lot of questions that are repetitive to the ones already asked in the admissions or the request for the form interrogatories, and it's a form of harassment. It's meant to intimidate you. It seems like there's a lot of work to do when in fact a lot of it is very repetitive, and you can often copy and paste responses to reduce your time getting them done. And today we're going to use a sample discovery from the Block firm, because Dennis Block is one of those firms that copies and pastes their special interrogatories, copies and pastes the admissions, copies and pastes the request for production of documents when they send them out to tenants, making very small changes, putting in your name, the tenant, the landlord's name, your address, dates that correspond to your case, but everything else, all the other wording is pretty similar. Sometimes there's small changes based on whether it's LA City or LA County, because there are questions about rent stabilization versus the Tenant Protection Act. And so those will be slight differences, but for the most part, they are the same. So we're going to use that as a guide, because remember, what I'm about to take you through is just a sample of special interrogatories. This is not necessarily the special interrogatories you received or might receive if you ultimately receive discovery down the road. Sometimes people attend the class that haven't yet received it, but they want to learn a little bit about it in case they do. We're going to get started now with the special interrogatories. And the first thing you've got to do is fill out the caption page. And if you already did the form interrogatories, this is very similar. I'm going to start actually with the middle of it because it'll help with the rest. So here, you're going to put the name of the plaintiff, and you're going to put it in exactly how it's written in the complaint. If it's misspelled, whatever punctuation is there, whatever spacing is there, put it in exactly as it is in the complaint. And then the next line is for the defendants. And you're going to, again, put the names in, or if there's just one name, put it in just like it's written in the complaint. And you're going to put all the names in here, even though each person, say there's 3 people that are listed here. Each one of you needs to fill out your own version of the discovery request. You have your own document. And so at the top of the page, the person who's responding to the document, the specific person of the 3 mentioned, named in the complaint, puts in their name here, their address, and their phone number, okay? That's the person who's responding to the request. Each person has to do their own. All 3 are named in the complaint, hypothetically, and all 3 have to be listed exactly as they are written in the complaint, but only the person who's responding, what we call the responding party, puts their name, address, and phone number at the top. You also put the case number, just like it's written in the complaint here. Below, again, propounding party is the plaintiff, so you put the plaintiff's name here. Responding party is specifically the person who's responding of the group here. So if there's only one person, that one person is here. If there's 3 people, it's the one person who's responding on this template, this document. The others have to have their own version, and on their version, they would put Perfect Tenant 2 or whatever their name is. Sometimes the complaint has the name spelled incorrectly, and you can correct it here. Otherwise, if it's spelled correctly here, just put your name here. Again, a place for your name, the person, the responding party, and the plaintiff, the landlord. And make sure you put in your actual name, the actual landlord name, not perfect evil landlord. That's just a sample. Okay. In this version, right? This version of the template, it's assuming that you're doing your responses within the deadline. So if you're responding within the deadline or within the extension, as long as you preserved objections when you requested an extension, we always say in TEP class, make sure when you request a 2-week extension, you also preserve objections. And that is to make sure you're allowed to object to any question you think might be irrelevant or might be written improperly. Sometimes questions are unintelligible. Sometimes they, in the admissions, for example, they'll ask you to admit to 2 different things or this or that, and that's not allowed. That's called a compound request. and that's not allowed with admissions, you can object, but only if you are responding within the deadline. So we want to preserve objections as much as possible. So we try to encourage people to get their responses done within the deadline, at least within the extension. If you are late with your responses, you need to remove the objections. The templates we provided in the chat, one of them has the objections already removed if you know you're going to be late with your responses. The other one has the objections still in, and you can check whether you actually want to keep the objections or waive them. Okay, so now we're going to go over some sample special interrogatories. The ones you receive could be completely different from these. It's okay. I just want to give you an idea of what special interrogatories are like, because they're questions, often repetitive questions, and they usually fall into 3 different groups. And one of them is to identify documents. And that's the first question here, which is identify each document which supports the affirmative defenses you have alleged in your answer to the complaint filed in this action. And the response we've put in is basically the same response that we put into the request for production of documents. Because what we're saying when there is a question in the special interrogatories that's asking you to produce documents, you're going to be producing all the documents you have related to the case in your request for production of documents. And those are almost always requested. Not every time, but almost always. I would say 90+% of the time you're served discovery, especially from Dennis Block, you're going to get the request for production of documents. Dennis Block's firm calls it demand for inspection and copying. It's the same thing. It's request for production of documents, and it means show us your evidence. And your evidence is what you put into your binder. And the first pass of your binder is usually everything, right? All the emails, text messages, photographs of the unit, bad conditions, everything you have, your lease, your proof of your rent payments, all the relevant evidence to your case, and usually maybe even more than what's relevant, but you're not sure exactly what's relevant yet. The questions that are asked in the request for production of documents section and the questions asked for documents and the special interrogatories can help prompt you what type of documents, evidence you need to include in your binder. Now, it's important to remember, we covered this in the trial binder class and also in the 18 Steps to Victory when we have the class on how to be a TEP Pro, that the binder you produce for your discovery has more information than what you'll ultimately put in your trial binder. Your trial binder is all the evidence you want to use in your case, meaning the evidence that supports your defenses in the case. And that's a more streamlined group of exhibits. In discovery, the other side, and both sides can request discovery, so both sides can ask for exhibits. You have to give them everything they ask if you have it. Sometimes you don't have it, you can't produce what you don't have. And so when you're doing discovery, it's important to remember you're going to give them everything they ask, even if potentially it hurts your case, because you can also do the same thing to the other side. You can ask them for evidence that you know the landlord has, that you want to see, because potentially you're going to use it in trial as an exhibit in your case. You can ask for evidence, they can ask for evidence, and your responsibility is to produce it all during discovery. And you don't want to think you're being clever by holding things back, because what if the landlord knows you have it and you didn't produce it? The landlord's attorney is going to file what's called motions in limine, which is motions to exclude evidence. During discovery, you want to give everything that you are going to want to use in your case, because you don't want the other side to file a motion to exclude. any of your evidence. Sometimes people think, I don't want to show them my hand. I'm only going to show them what I want them to see, which is not very much, and I'll surprise them in trial. That doesn't work. That evidence will be excluded because you didn't follow the rules, which is to disclose evidence and explanation in your discovery process. And so when you come to questions about identifying each document, they're asking you to produce evidence. Now, this in special interrogatories, this is repetitive because if they've already asked you to produce documents in the request for production of documents, then you've already done that there. And so this is repetitive. And so we put in the same response here that we put in the request for production of documents, which basically says initially this paragraph right here, which is what we use in all of the special interrogatories. Basically, the summary of this paragraph is it tells the person reading it, the other side, the answer to your question may be found already in the request for production of documents, my exhibits that I produced with those responses, or with the form interrogatories unlawful detainer. Basically saying, I may have already answered your question in one of those two places, look there. That way you're covered. If your answer that you put in isn't thorough for the question they're asking, you're saying, look for the answer in this place or that place. And very often the answer is already there. In this case, it's definitely there because if you've attached your exhibit binder with the request for production of documents, this question is repetitive, and you're going to put in the same response here that we put in the request for production of documents. We'll get to the production of documents later, but this is basically a paragraph that we put in for those responses. And it basically says the exhibits you're looking for are in these categories in my binder. This language needs to be updated. We have a more complete version of this. I'll update this for the next class. But basically, this is the response to the request for production of documents. All the responses to the production of documents are the same. They are basically saying that the document or exhibit you're looking for, the evidence you're looking for, is in my exhibit binder, and I have scanned that exhibit binder and attached it with these responses. So every time you see in a special interrogatory, identify each document, we put in this same exact response, copy and paste. And we'll get to some of those as we go along. The next type of question that is asked, as to each of your responses to the first set of requests for admissions, which are served upon you concurrently, state each fact, okay? When I'm doing a block discovery like this one, I almost don't even bother reading the full question, to be honest, because I look at what type of question is this? Which of the three? Is he requesting documents? Is he asking me to state each fact? Or is he, look at question number 3, asking me to identify each person? Those are the three main categories that Block uses for all his special interrogatories. There is a few exceptions, and we'll get to those, but most of the ones he asks you to identify a person, state each fact, or produce documents. And you can pretty much copy and paste if that is the correct response. For identify each person, sometimes the identity of the person might be different based on the question, right? It might be a different person based on the question, but it's a simple answer. It's asking you to name the people involved with something, and you just have to put in those names. That's pretty straightforward and simple. But for the ones that state each fact, like in question number 2, what we typically do, this is what Elena has asked TEP students to do when they get a question that in the special interrogatories that ask you to state each fact. is to write out all your defenses. You're going to go through your answer and look at all the defenses you've checked, and you're going to write out the story behind those defenses. You write it as if you're telling a story, paragraph after paragraph, writing how each of those defenses that you raise are relevant to the case. What makes those defenses that you can use? And you write out the explanation into a long, sometimes multiple paragraph response. And you're going to do that once, because every time it says state each fact, you can copy and paste that response. Sometimes special interrogatories are written a little different. They might not say state each fact, but when you read the question, that's sort of what they're getting at. They're asking you to state some facts or explain something. And you don't necessarily have to explain just the one thing that they're asking. You can put in that paragraph, that massive story that is an explanation of all your defenses. Do it once, make it thorough and complete, and then copy and paste it in all of the places it's asking you to explain some defense you have. It's almost the opposite of what Elena tells us to do in court, right? In court, when the judge asks you a question, she says, answer the question and only the question. But with discovery, you don't have to do that. When they ask you a question, you can put in a story that covers not only that question, but every other defense you have. It just saves you time. You do it once, and then you copy and paste that story every time it tells you to state each fact or to explain some defense in your case. Question 3 is about identifying each person. In this instance, it says, as to each of your responses to the first request for admissions, which are served upon you concurrently herewith, which means we served you discovery, including admissions, requests for admissions, and now they're saying, identify each person with whom you believe has knowledge of the facts that support your responses. And so you look at the admissions, the request for admissions, and who are the people that are potentially witnesses in your case. If you've been working on your trial binder and you've been coming to the trial binder class, which hopefully you all are, Shay goes over the witness list. And she talks about how you put in any person you think has information to back up your defenses, even if you don't think they would be willing to appear in court. Don't worry about that right now. You can always remove witnesses. You can always subpoena witnesses. For now, you want to put in all the people who have evidence of the facts. So if you got requests for admissions and you look at those questions, who are the people that have evidence to back up your responses to those questions? That's what this question is asking here. And anytime it says identify each person, you're just going to put in the names, not the story, just the names. Special Interrogatory 4 is another identify each document question. Okay. So what is the response? The response is the same as the response to the first one up here. This one is saying, as to each of your responses to the first set of requests for admissions, which are served upon you here concurrently within, which shall be on an unqualified admission. An unqualified admission means you answered either deny or admit but, or admit only to. Sometimes, sometimes it's 100% admit. Like they'll ask a question about, do you still live on the premises? Are you still an occupant of the unit? And they'll put the address in. And for that question, if you're living there, is admit. There's nothing more other than admit. And that's an unqualified admission. Anything else where you might say deny or admit, but you qualify it with something, meaning I admit only to this, not to that. If you put in anything other than simply admit, it's asking you to identify any document that supports that response. But this is a repetitive question because you already have all your exhibits attached as your request for production of documents. So you don't really have to get caught up in what the question is asking. You're just going to attach your binder of exhibits. And that's what this response says. It has the same paragraph here that says the answer to this question might be found in my responses to your form interrogatories unlawful detainer or the request for production of documents. Look there. And even though we don't necessarily have to, we put in the response that we put in for request for production of documents, which is, here is my binder broken into categories. Look for your answer there, because they're asking for documents, and those are where your documents are. Special Interrogatory 5, describe fully each communication. This is a good example of another way of writing state all facts. Describe fully each communication occurring anytime during the past 2 years between you and the propounding party, where subject matter is related in any way to the persons occupying the premises. And this should be the same response that you gave to question 2, which is a very thorough explanation of all your defenses, because anything that's in there to back up your defenses is going to be an answer to this question, because it's asking for evidence of communication between you and the other party over the past 2 years. And if you have any defenses related to that, you would put them in your paragraph, your general story of state all facts. Look at your answer as a guide. Those are the defenses you raised against the eviction, and those are what you want to explain in your paragraph, and then copy and paste it anywhere it says describe fully or state all facts. Here is one that is a little bit different. It does say describe fully each payment of rent, and technically your response is already in the form interrogatories UD if they checked it. There is a question that asks the exact same question, except it's 12 months. It's almost exact question. It asks for your rent payments over the last 12 months. This one says 6 months. But what do I do when I'm helping someone with this question? I just copy and paste the answer from the form ROGS unlawful detainer. We've already filled out this chart there. There's no reason to fill it out again. Just copy and paste the chart and put it in here. And I'll show you just to help you understand what I'm talking about. Right here, 71.3, list all rent payments and credits made, beginning 12 months before the notice. So this question is always checked by the block firm, often checked by the other firms, especially in non-payment of rent cases. And so if you've already filled it out here, there's no reason to redo it. Just copy and paste it and put it in the special interrogatories. Right here. Special Interrogatory 7. If you contend that the plaintiff, the name of the plaintiff, lacks standing to maintain this action for the unlawful detainer, state each fact which supports that contention. And remember what I said, when it says state each fact, you're going to put in that same response, that full explanation of all your defenses that you put in question 2 as a response to question 2. Why? Because if you checked lack standing as a defense in your answer, you're going to write out why you think that is a valid defense in this case. And you're going to put that in all the responses that say state each fact. Remember, you're going to write out an explanation of all the defenses you raised in your answer into one long story, multiple paragraphs, perhaps. I've sometimes had, when I've written this to help some tenants, I've sometimes used 2 full pages to write out the story. And, you summarize it the best you can, but you can put in as much detail as you want to, and then copy and paste it every time it says state each fact or describe fully. Next one, again, identify each person who is in possession of the premises. This one is just asking for who is living in the unit. Perhaps it's one person, perhaps it's more than one person. You name the people who are in possession here, if that's the question. Number 9, describe fully. Remember, describe fully is just like state all facts, each agreement by which you contend you have ever had a right to possession of the premises. This is basically asking you to describe your lease or rental agreement. And so you don't have to write out all the terms of the rental agreement. You can just say, usually this is already asked and answered, right? Because there are a couple of questions in the form interrogatories UD about it. So it's asked and answered there. There's also usually questions about it in the request for production of documents. And so if it is already there, then you don't have to do anything more than just leave this paragraph in here. Because it's basically saying, this question you've asked, I've already answered elsewhere. And if you've already put your lease or rental agreement into your binder, which everyone does, if you have it, then you've answered this question in the request for production of documents, because you've attached, when you send in the request for production of documents, you send in your scanned binder with it. It will make more sense when we get to request for production of documents, but I think it's pretty self-explanatory, hopefully. But we'll cover it in a little bit more detail when we get there. Special Interrogatory 10, describe fully the circumstances by which you received the first notice. Now, a lot of times people contend that the notice wasn't properly served. And this question is asking to describe the circumstances in which you received the notice. Was the notice posted in a conspicuous place or not? Was it posted and mailed as is required? Very often it's not. Sometimes it's only posted. Sometimes they post things on the door with one piece of tape and it falls off and flies into the neighbor's yard. Maybe your neighbor brought it over to you a couple days later. Whatever the case is, it's asking you to describe fully the circumstances. However, if you have raised this as a defense in your answer, then you've already written about it in your long story for the response to Special Interrogatory number 2. This is the long story with multiple paragraphs of all your defenses that you're just going to copy and paste. In any place it says describe fully or state all facts. Because if you raised it in your answer, then you've written a paragraph about why that's a defense. Special Interrogatory 11. If you contend that any of the matters stated in the notice are false, state each fact which supports that contention. When it says state each fact, what do? You copy and paste the response you've written to Special Interrogatory number 2. And I'm talking about block discovery, right? If you receive someone else's discovery, right, chances are it's not going to be necessarily question number 2, but there's likely a similar question where they're asking you to state something to back up a defense you raised in your answer. And you're going to, as I said, write out the full story for all the defenses one time so that you can copy and paste it into any question like this. You don't have to necessarily answer the individual question. You can write a story about all your defenses and copy and paste it. Special Interrogatory 12. If you contend the notice did not fully comply with all requirements of the Los Angeles eviction moratorium, state each fact. Again, state each fact. You leave this paragraph in, you copy and paste the response that you put in for your explanation for all your defenses you raised. If you're suggesting in your answer that the landlord violated either the Los Angeles eviction moratorium, or sometimes it says the Tenant Protection Act or the Rent Stabilization Ordinance, then you're going to put in as a explanation to your defenses, a paragraph about why you believe that is true. Why is that a defense in your case? You write out all the story for your defenses and copy and paste them into these answers. Special Interrogatory 13 says, if you contend that the plaintiff has accepted rent for the premises from anyone anytime after the date, state each fact. If, in fact, the landlord accepted rent after where it says date here is meant to be the date the notice expired. So if you have a non-payment of rent case and the landlord accepts rent, say you didn't comply with the notice, you missed complying with the notice, technically the landlord could file an eviction lawsuit any day. Maybe they're in the process of doing that, and you say, here's my payment, and they accept it. And maybe it's a portion of what you owe, not the whole thing, but they accept it. And then they file a UD based on, in their minds, the rest. But the notice had the full amount. And once the notice has expired, the landlord is not legally allowed to accept rent. They are giving the court jurisdiction over the case. Once you file your answer, you're giving the court jurisdiction over the case as well. But if the landlord accepts rent outside of the court, that is a violation. And your tenancy could be reinstated. Not definitely, but could be reinstated. Very often that can dismiss the case. And so they're wanting to know if you believe that to be true. And chances are, if you've written your answer after the landlord did accept a partial payment or some form of payment towards the rent after the notice expired, then you've raised that as a defense. It's part of your story, and you can copy and paste your full story here along with this paragraph. This paragraph always stays in. You're only going to add to it, copy and paste a response that you put in that has an explanation of all your defenses, not just this one. Hold on, I need to take a sip of water. Number 14, if you contend that the plaintiff is estopped to enforce the notice, state each fact which supports that contention. And waiver and estoppel are two of the most common defenses that are included in the in answers. Very often, when you get assistance from self-help centers or from EDN, they'll check waiver and estoppel because it's so common. Not necessarily. It doesn't necessarily happen in terms of the notice, which is really what they're trying to get at. But waiver is when the landlord changes an agreement. In the easiest explanation, and I use this one all the time. I use it when we have this question in the form interrogatories, unlawful detainer. A waiver is when the landlord changes an agreement in a way that potentially has legal consequences or changes the consequences. For example, if your lease or rental agreement says that your rent must be paid on the 1st, or you get a late charge, $50, hypothetically, and you pay it after the 1st, maybe there's a grace period, you pay it after the grace period, and the landlord says, that's okay, you paid it, I'm not going to charge you a late fee. That creates a waiver. That's a change in an agreement. The lease said this, or the rental agreement said this, but now my landlord is changing that agreement to say, I can pay the rent late without consequence. And now, if you're lulled into believing going forward that you can pay the rent late without consequence, that's where estoppel comes in. That's where the landlord has changed an agreement in such a way that it changes your understanding of the relationship based on that specific agreement. And sometimes landlords give multiple notices when they're trying to file an eviction. They'll file a notice and it'll end, you won't comply, it'll end, and then nothing happens. The landlord doesn't file an eviction. They
No, I was thinking Hillary might be in here.
hold on a second. Gotta just fix that. I think we have someone unmuted. Hold on a second. Okay, so when you're lulled into a new understanding, that's where estoppel comes in. And so the argument here is that the plaintiff can't enforce the notice because they previously filed a notice with you that they didn't follow through with. And so you were lulled into believing my landlord posts these notices but doesn't do anything. They don't ever actually act on them. And so why did they act on it this time? Right? I was lulled into believing that the landlord posts these notices for me to know about them, but not without any consequence. So anyway, if you raise estoppel, which is very commonly raised in answers, then that's part of the paragraph, that long explanation of story, state each fact. You're going to put all your story, all the explanation for your defenses into one long story with multiple paragraphs, maybe one paragraph for each of those defenses, and you copy and paste it every time it says state each fact. And that will then cover estoppel if you check that as a defense. And here's the waiver question. Same thing. Waiver is specifically about the act of changing the agreement. Whether it's changing an agreement about the date that the rent is due, late fee if it's past this date, and then now there's no consequence if it's paid late. That's an example of a waiver. When there's a notice that is filed or posted by the landlord, not acted on, then they post another notice. Maybe that one's not acted on, they post another notice. My landlord, in my case, did that. I think I probably got at least 5 or 6 notices before they acted on it. In those instances, that is a waiver. That creates a situation in which I might then expect the landlord is not going to act on any of them. I don't think this is necessarily a strong defense, but it is still something that is raised. Estoppel, I've heard tenants win on estoppel. So you want to make sure that you check those defenses on your answer and you explain them in your story of your defenses here, copy and paste the same response to with all your explanation for all your defenses. I'm going to say it every time. You're going to copy that story, copy and paste. So you want to write it one time, perfect, thorough, and copy and paste anywhere it says state each fact, because these questions are looking at your answer to see defenses raised. And the block firm knows that people frequently put in the defense about waiver. They frequently put the defense in about estoppel. And so he's asked a question asking you to explain, state each fact to back it up. And you're going to write out your story and copy and paste it every time it says state each fact. And there's more state each facts coming up now. Number 16, if you contend that the plaintiff served the notice to discriminate against you, state each fact, right? Discrimination and retaliation are defenses frequently checked in answers. Why? Because there's no way for you to get into the plaintiff's head to know their motivation for evicting you. You might not think it was discrimination. You might not think it was retaliation, but do you know for sure? There's no way for you to know for sure. You'd have to get inside their head to know their motivation. Maybe they have more than one reason for trying to evict you, and discrimination or retaliation may be part of it. And so it's a legitimate defense to raise because there's no way to know for sure. If you do have evidence, all the better. Sometimes landlords tip their hand. They'll tell you things that are discriminatory, or they'll explain to you that they're mad at you for doing something, like reporting a bad condition to the LAHD or some other type of government agency. If you're reporting, something that should be improved, that you've asked the landlord to improve, but the landlord hasn't done it, then you have every right to try to get that resolved, if not through the landlord and the property manager, through the government, through one of these agencies. And the landlord, the plaintiff, is not allowed to retaliate against you for exercising your tenant rights. And that's where that comes into play. But most importantly, it's for you to remember that some of the things that they ask you about, you got to really think it through and ask yourself, do I know for sure? Or is this something I would have to be inside the plaintiff's head to know, in which case it's possible? And then you can raise it as a defense and then explain as part of your story, and copy and paste anywhere it says state each fact. Number 17, if you contend that you are not required to comply with the notice, state each fact which supports that contention. Most likely, you've raised in your defenses, in your answer, reasons why you think you didn't have to comply with the notice. Something that was done wrong by the landlord. And you've raised that in your answer, and you've written it as part of your story, the multiple paragraphs that you've used in other responses above, and you can use it again here. Remember, you always keep in this paragraph, you're only adding the story to it. And the story that you add should be full explanation of all the defenses in your answer. You write it once and copy and paste it. Special Interrogatory 18. If you contend that you complied with the notice at any time, state each fact which supports that contention. And once again, leave this paragraph in and put in the full explanation of all your defenses after it. Special Interrogatory 19. If you contend that at any time usually this might be the date of the notice. Usually it's the date of the notice. The fair market rental value of the premises was ever below. This is the daily rent. This is your rent divided by 30 per day. State each fact which supports that contention. This response is different because in this case, it's pretty much asking you to be are you an expert on fair market value? And so this is the response that the EDN attorneys has suggested. You should if you get this question or something similar to it, you can use the suggested response from the EDN attorneys, or you put in your own response. Just make sure that whatever you put in is true for you. If you're not an expert, this answer is sufficient. Question number 20. If you contend that at any time during your occupancy of the premises, the plaintiff breached an implied warranty of habitability at the premises, state each fact, right? So, warranty of habitability is a breach of warranty of habitability means the landlord has promised to give you a habitable unit. If there are bad conditions in your unit, especially ones that you have identified to the landlord, asked to be repaired, remedied in some way, and if the landlord hasn't responded at all or in a reasonable amount of time, you want to make sure you capture that in your answer and in your evidence. And the best evidence for bad conditions is the evidence that you collected during your tenancy. If you only are providing evidence after the notice from the landlord, and then you're asking for these fixes to be made, it carries less weight because you're trying to remember, in your case, there's usually a period of time in the past that the landlord is talking about you need to comply with the notice, especially when it's a payment of rent case, because they're saying you owe rent from the past and very often identify the months. And so did these bad conditions exist during those months? And do you have documentation, evidence that you had those conditions during those months and that you communicated to the landlord either during those months, before those months, shortly after those months, that these conditions were a problem, giving the landlord an opportunity to remedy them? And how did the landlord do? Did they fix them completely? Did they, come say they're going to fix them, but maybe did a Mickey Mouse fix that fell apart shortly after, and now it needs to be fixed again? Or did they not fix it at all? Maybe they did fix it, but they took a really long time, an unreasonable amount of time. And you want to capture all of that in your evidence. And if that is part of your evidence, it's also part of your story that you've written out as your defenses based on your answer. And so once again, state each fact, you can put in that story here. You can also, even though this response here says, look to the form interrogatories UD, look to my production of documents for your answer to this question. And hopefully you do have evidence in your binder, request for production of documents portion. Hopefully you do have evidence there that supports the bad conditions you're alleging in your answer, if you are in fact alleging them. But also in the form interrogatories, there's a question, 75.1, I believe it is, here, asking about all the things that needed to be repaired in the unit during your tenancy. And you've hopefully put in a very thorough answer here. And you can copy and paste that answer into the form interrogatories question about bad conditions, because you've already done that work. You don't have to do it twice. We're trying to save you time to get you these responses done quickly. Very often tenants rewrite over and over the same stuff. You don't have to do that. You can very often find the answer somewhere else, copy and paste it in. Lots of the questions that these law firms ask are repetitive, and they're doing it to intimidate you, to take up time, to make you, they're hoping to make, you'll see the questions and say, oh, I don't have the time to answer this. I can't do this in 5 days. I'm just going to move out. That's what they want you to do. We're here to help you respond to them so that that doesn't happen. Don't be intimidated by the packet. Come here, learn how you can save time by copy and pasting. Number 21, if you contend that the plaintiff served the notice to retaliate against you, state each fact. We already talked about this when we talked about discrimination. Retaliation is another one of those possible defenses that's difficult to prove if the landlord didn't retaliate, because you'd have to get inside their head. Is it possible they retaliated against you for something that you did that really they have no right to retaliate against? Retaliation is not allowed. So if you exercise your tenant rights in some way and they then retaliated against you and tried to evict you for that reason, sometimes they are very overt in the way that they, in the open, about how they are retaliating, but other times you might just suspect it. But even if you don't suspect it, it's hard to rule it out because you'd have to get inside their head to know for sure. It's a very common defense in your answer. And you have it, if you have more explanation, you want to make sure you include it in that big long story, that paragraph after paragraph about your defenses, and you copy and paste it here. Always leave in this paragraph here. This paragraph says, I may have answered your question elsewhere in the other discovery request. And then you're going to add to it by putting in the story of all your defenses raised in your answer. Number 22, if you contend that you did not receive the change of terms of tenancy, this is a specific question. This is a specific question about the notice. So This might say something different. This might say, if you contend that you did not receive the notice to pay rent or quit at any time during your occupancy at the premises, state each fact. No matter what it's saying, it's usually talking about the notice. In this case, the person's notice was included a change of terms of tenancy. If yours is pay rent or quit or whatever it is, it's once again a state each fact question, and you're going to leave this paragraph in and add your story, all the story that explains all your defenses. And we're on the last question of the special interrogatories. Now, this is the last question for Dennis Block. Dennis Block typically does ask about 25 or less special interrogatories, usually between 20 and 25, depending on the case. Sometimes a few more. But the maximum they're allowed to ask is 35. And so if you are asked 36, 37, and there's no explanation for those additional requests, the plaintiff is required to include an affidavit explaining why they would need to request more than the legal limit, which is 35 special interrogatories, 35 requests for admission. If they go over that limit and they don't provide an affidavit explaining why that is necessary, then you don't have to answer those questions. You can object. You can just say you can just say objection to the question number 36, question number 37, if they have them. And we have had instances where the plaintiffs have tried to ask more questions than are allowed. Sometimes they have included an affidavit, sometimes they haven't. If they don't include it, then you can object and not answer those questions. 23. If you contend that on such and such day you were not served with a 3-day notice, state each fact which supports that contention. Once again, this is a similar question to one already asked about the notice, about service. And so once again, state each fact, leave this paragraph in, use the long story that explains all the defenses you raise in your answer, copy and paste it there, and you're done. Now, sometimes the questions are very specific in the special interrogatories, in which case you're still going to leave this paragraph in, but you're going to answer it. Okay? Not all of the questions in the special interrogatories are like the block form. If you get questions that are very different from these, and they're asking for specific answers, a specific date, a specific number, sometimes they're asking for information about your bank account, things like that. And if you're unsure how to answer, always reach out to your attorney law clerk team and see if someone's available to help you understand the question. We can't necessarily assist you with the answer, but we can often assist you with the question. You can always come back here or come to my office hours and I'll try to help. My office hours are Monday through Friday at 8 a.m. using the same link that you used to join this class. Okay, at the end of every portion of the discovery, the special interrogatories, just like the form interrogatories, requires you to put a date and signature in. You're going to put the date and signature in on the date you send the responses in. So hold off on doing that until you're done with everything. Once everything is done and you're sending it on that date, put in the dates and the signatures to each section. And we'll get to the service in a second. So now there's 2 different versions of the verification form. You only need to use one. The first one is if you're English speaking and you fill out the name of the responding party, whoever the person is, the defendant, tenant that's responding to the discovery, and the date and the location. Again, it should be the date that you are serving, not when you're finishing that section, when you're serving, giving the other side your responses. This verification form is for people who don't speak English. in which case someone had to translate the requests and the responses to that person. And so they have to sign, the defendant signs that they had those responses read to them, translated to them. They sign here. The person who does translation has to do a separate declaration that they did translate the requests and responses to the defendant, or the responding party. Next is the proof of service. Every section has to have its own proof of service, even though you might be sending it together. You can also send portions of the discovery separately. If you finish one section, like, or one or more sections before the deadline, but maybe something is going to be late, you can send the portions that are done within the deadline. But you got to be careful, because certain sections point to other sections, right? Like the form interrogatories, unlawful detainer, reference the request for production of documents. The special interrogatories, if they request documents there, point to the request for production of documents. And so if you send the specials or the form interrogatories ahead of the request for production of documents, you're technically pointing to nothing. So you've got to be careful. Make sure if you point to the request for production of documents, or you point to the special interrogatories, the form interrogatories, unlawful detainer, that you include those together, that you send them together, so that when they read them, it makes sense. Hey, they're saying to look here or look here, and they have included those responses. Okay, so here you put the address. In this case, this is filled out as if an EDN employee is doing the proof of service, because it has our EDN office address here. The important thing to remember is the person who's serving the documents, your responses, to the other side needs to be an adult, age of majority, 18 or over, and not party to the action. If there's tenants that live in the unit that are not named in the complaint, they can be the proof of service. You can ask a friend, you can ask a family member, and if you have no one else, you can always try to ask us to serve your responses for you. It does not mean that we assisted in the responses. It just means we're helping you serve them. Okay, you want to make sure that this date here and the date at the bottom match the date of service. It's funny, they don't actually match here, but these weren't served. Lots of these fields update automatically, and some of them don't. So that's why that might have happened. But anyway, the numbers, the dates need to be the same, and they need to be the date of service. And in this section, even if I'm not serving first class mail, I typically put in the address of the firm. And then very often how I serve is email, and it's the most common form of service. You must check here the type of service you use. You can use more than one. You can serve it 3 different ways if you want. Up to you. Sometimes people want to be absolutely sure that the other side received it. And just so you know, when you send it by email, not many of the firms will respond to say that they received it. So don't worry if you don't get a response back. You're going to want to use as many email addresses as you can find for that firm. They will usually put at least one email on the top left of the discovery request. You want to make sure you include that one. But if you also know others for the block firm, I always use Dennett Block, and the person who's the #1 minion to Dennis Block is Grace Long. I always put her email in there as well. The more emails you put in, the less likely they can say they didn't receive it. So in all my time serving to the block firm, they've never contended. I shouldn't say that. They have contended in court that they didn't receive. They filed motions to compel, but we called them on it. We said, hey, we sent you the responses ourselves, check. And they said, oh, yes, we see them. You're right. And they corrected it, and they took the motions to compel off calendar. That has happened. But I've in most instances, they uh, they don't contest, when you send them, because they do check. But if they don't check, if they file motions to compel, even though you sent responses, you want to make sure you bring the proof, evidence that you served them to court. And if you get a motion to compel from any firm, you're going to want to write an opposition to that. Sometimes we're available to help, other times not. If we were involved with the responses, chances are more likely we'll help in some way, even if we just give you a template and give you some guidance how to fill it out yourself. But as part of an opposition, you got to write a declaration of sort of like who you are and the facts, and you're going to explain that you did serve them, they were served properly, the responses were done complete, you served verified responses, meaning you signed the verification page, and so serve them on this date, and you will produce evidence in court of that service. That's only if you get motions to compel after you did serve properly. Now remember, check the box of service. They can say it's not in compliance if it's not checked. And you're going to include the email addresses if you're emailing the responses. When I was served, I sent them via email, and I did personal service because the block firm was just 10 minutes from my house. So I went there and brought my responses to them in person. I wanted to make absolutely sure they didn't, after doing all the work, you want to make sure that they receive it. So at the end, once again, you're going to put the date of service here, and you electronically sign or handwritten sign here. And that is the special interrogatories. Now, we're going to jump past the request for admissions only because your law clerk, your attorney law clerk team, is most likely going to assist you with those. And if they're not available, they're most likely going to contact me, and I will assist you with those. So you're not likely to have to do them on your own. Okay. So anyone out there in the class, if you have requests for admissions that aren't done yet, please contact your attorney law clerk team. I posted the attorney law clerk teams in the chat and the phone numbers to communicate with. You always want to let them know you received discovery. Even if you didn't receive admissions, you want to let them know you received discovery. Monday through Friday, 10 a.m., send your updated PIP with a received discovery. It's due this date. And if you received admissions, can you assist me with the responses to the admissions? And hopefully they can. Otherwise, they'll likely contact me and say, Mark, do you have time? And I will make sure you get them done. So we're going to skip over these. Just in general, quick. Admissions are statements that you either admit or deny. They're basically true or false. Sometimes they ask you questions you won't understand or really know how to answer, and you can respond in kind. You're only going to admit things are 100% true. Anything else is denied. If it's 99.9%, there's any room for doubt, you put in deny. But the attorney law clerk teams will help you with those. If not, I will. So we're going to skip over those in this class, and we're going to move right to request for production of documents. And request for production of documents is pretty simple. And to explain, it's a lot of work for the tenant because it's asking you to produce all the evidence. And once again, the evidence that's asked in discovery can be anything and everything. They can ask you for things going back to the beginning of your tenancy, even things that you might think, wait a minute, how is this relevant to my case? They can ask for anything, and technically, whatever they ask, you're supposed to give it to them. And even potentially things that you might think might hurt your case, they are entitled to evidence, just like you're entitled to their evidence, things that might hurt their case. So remember that. Don't try to exclude things because you can get in trouble, because you have to sign under penalty of perjury that you've responded completely, accurately, truthfully. And so don't try to hide things that that the landlord knows you have. You could get in serious trouble. And so could the landlord if they try to exclude things, if you ask for their evidence. And so once again, when you get to this section in the template, you're going to put the evil landlord and the defendants as they're named in the complaint, exactly as they're named in the complaint, case number exactly as it's written in the complaint, and the person who's responding, the responding party. If there's multiple tenants here, only one person is the responding party in each document. And that person puts in their name, address, and phone number at the top, and also puts in their information under responding party. You can correct the name if it was misspelled in some way here. You can correct it here. And then objections are kept in if you're responding in time. Very often, request for production of documents is one of those things that takes more time because it's a matter of collecting, gathering all the evidence, and then getting it into a binder and getting it all scanned. And very often when you're producing discovery, there's a lot, right? Because it's all the kinds of things that they can ask for, anything that's related in any way to your case, not necessarily things that are supportive of your defenses, anything they can ask. Anything, any communication about the time you were there between anyone, the landlord, the property manager, anyone related to the case, you're technically supposed to produce. And so that can take time. Very often people are late with their responses to the request for production of documents. It's important to get it right, so you don't want to rush it. Because ultimately, this is the foundation for your trial binder exhibits. You're going to end up working with your attorney law clerk team to figure out which of all that evidence is actually relevant to the defenses you raised in your case. And that's what gets kept as exhibits in your trial binder. Everything else will be removed. And usually the the law clerks will do a first pass, and they won't take anything out. They'll put it in potentially discarded, and then the attorney will review it to decide what is actually relevant. Are the things that were removed actually not relevant? If so, they can be taken out of the binder. And the trial binder is what you use in court for trial to present to the jury. You ultimately merge your binder with the other side with their evidence, and they're going to only include in their trial binder the evidence they're going to use in their case, just to support the defenses, or not the defenses, but to support the whatever they're alleging you have done wrong. You're going to put in evidence to support your defenses. Anyway, okay, so we're going to go on. We're going to go on. Now, the beautiful thing about request for production of documents is that the responses are the same. I'm actually going to fix it really quickly for one, because this is an older version, how we used to respond. I want to put in the newer version, so just give me a second. Now, the response to each request is always the same, and it will make sense when I show it to you. I'll explain it. Okay, so this is the current version of the response we put in for requests for production of documents. No matter what the question is, okay, You should go through all the questions as a guide for what you put in your binder. Often the questions will jog your memory of things related to the tenancy. So don't discard them. Use the questions as a guide, but you're also going to include as part of your evidence all the things related to the tenancy that you want to make sure you include that support your defenses that you raised in your answer. Okay. And the response is, after reasonable inquiry and diligent search, the responding party will produce all responsive and non-privileged documents in their possession, meaning you have them, custody or control. You can't produce what you don't have. So if you have it, you're required to produce it. If the documents are in your possession, they can be found in my exhibit binder, basically, is what it's saying. And your exhibit binder is broken up into these categories. If you've attended Shay's amazing trial binder class, last week on July 4th, we covered exhibits. And she covered these categories. And she talked about how to add that evidence properly to your binder, how to putting it in chronological order from older to newest, and also how to number. And remember, when we put in the evidence initially, the everything, we don't focus on the numbering like we do when it's going to trial. When it goes to trial, every single piece of evidence needs to be on a line in the exhibit list. It needs to have that corresponding number in the binder. And so we don't do that minutia detail at this stage. We just put in all the evidence in chronological order based on the categories. Okay, so exhibit 101 is always the lease or rental agreement. Exhibit 102 is always your proof of rent payments. And you'll notice it says, if applicable, for each one, meaning if you have that evidence, if that applies. Sometimes people have a verbal oral agreement that they can move into a unit. And sometimes the only term is the monthly rent. It's this amount. You pay this much per month. That's the agreement. And you can move in. Some people have that simple of an agreement. It's verbal. And so they may not have a lease or rental agreement. So that's why it says if applicable, because maybe this person has an oral agreement. Exhibit 102, rent payments, proof of rent payments. This is all that apply. You should make sure that if the notice demands so many months, you cover those months. But typically we make sure we include 12 months prior to the notice, longer if the demand is larger. You can put in, sometimes they ask for everything you have since you moved in, which can be a daunting task for someone who's been living in their unit for 30, 40 years. Exhibit 103 is communication between the parties. And it's important to remember that this includes a lot of different things. It can be text messages, it can be emails, it can be letters, it can be notices, it can be faxes, whatever it is that's tangible communication between you and either the landlord, property manager, anyone who has, could be a neighbor communication, because you're going to have, you might have evidence, supportive evidence from a neighbor. A neighbor might corroborate something. But especially this is between the parties. This is communication between you and the plaintiff, or the landlord, the property manager, because a lot of times we communicate things that we want to show the jury. We communicate things like, telling the property manager or the landlord that you've got this problem in your unit, and you're going to put their response, which is sometimes that they're not going to do it. Sometimes they don't realize that this is going to end up in an eviction case, and they say things that will help you because they didn't know it was going to end up in court. And you have that evidence with you, communication between the parties. At the very least, you want to make sure you've communicated, hopefully, about the bad conditions in your unit, or about whatever it is that is wrong, that you communicated it with the landlord, and you get the landlord's response in writing. When I was dealing with my case, when, before the actual eviction lawsuit was filed, but I knew the landlord was going to file it eventually. She had been harassing me. She had been posting notices, but not acting on them. I made sure all the communication we had was in writing. She would call me and I wouldn't answer. I would text her back saying, I saw that you called me. Please make sure that whatever question you have, you put it in writing. You can email me, you can text me. And sometimes she would write back something, or sometimes she wouldn't. And if she didn't, I knew she was probably trying to say something to me that she didn't want, record it some way in a written form. And so remember, best communication, no matter what. I mean, it may be too late in your case to get all this kind of communication in writing, but remember, for the future, wherever you go, if you end up moving, to always keep communication with your landlord, property manager in writing. Make sure you always make your payments, right? No cash payments. Don't ever use cash to pay rent ever again if you did it. Make sure you use cashier's checks or money orders, because you want to always have evidence of your rent payments. And you always want to have evidence of your communication with your landlord or the property manager or whoever else you might have communicated with about something to do with your tenancy. Exhibit 104 is photographs of the interior, and this is mainly bad conditions. So if there are bad conditions that exist, whatever it is, plumbing, electrical, things, peeling paint, plaster falling from the ceiling, often mold is a problem because water tends to get into old buildings and create mold, which can make people sick. Some of the best evidence to have hits one of three main areas, which is health, safety, or security. Okay. And you think of health, the things that can make you sick. Safety is when you could get injured as a result of something not being safe, like maybe the common areas, the stairwells are about to fall apart, the entrance has stairs and they're falling apart. Maybe they're all rotted out and falling apart, and you could potentially get injured as a result of the landlord not fixing them. That has to do with safety. Security has to do with things like locks to your unit, or locks to the building, or locks to the gate that allows people in, because strangers could enter the property and therefore create a safety risk because they've not kept the building secure. Very often, vagrants can enter properties and do damage. And you want to, when it comes to 104, it's focused on interior, things in your unit. And 105 focuses on the common areas or exterior. And that's capturing photographs of bad conditions in the hallways, in the laundry room, the mailbox area, the entranceway, the garage. Exterior is also part of your tenancy. If there's a gate that lets people in, if that's not secure, you can have photographs of that. Sometimes there's exterior lights that are not on that create a potential hazard, a risk. Lots of different things that you should think about, whether they are bad conditions, and you want to make sure you have photographs of them. Exhibit 106 is video evidence. The courts don't love video evidence, but it still applies. You want to keep the video short, and you want to make sure you only use video for things that move, like leaking water or rats or roaches. Best to only have video evidence of things that move. Anything that you can capture successfully, thoroughly through a photograph, use a photograph. Don't use video. And keep the video short. Once you made the point, stop. And edit it shorter if necessary to include only the portion that makes the point. And that's Exhibit 106. And then the rest are things that may or may not apply based on the unit. Sometimes people live in single-family homes. Sometimes people renting apartments. Sometimes people live in a rent-stabilized unit. Some people are protected by the Tenant Protection Act. Some people have evidence of reporting the property to a government agency like LAHD, and you have either reports or notices relevant to that. Sometimes people are sued for rent during the pandemic, in which case you can provide evidence of COVID impact and declarations you may have submitted to the landlord during that time. You want to put your proof of COVID impact here. A lot of times people thought, how can my landlord evict me? I was impacted by the pandemic, it affected me in some way. Well, even though you have defenses for that, if those defenses hold up, the landlord can challenge your defenses. It doesn't mean just because you think you were impacted doesn't mean that that's it. You have to prove it. It's court. The landlord is allowed to challenge your COVID impact. You need to be able to produce evidence. And that goes for everything, right? I mean, a lot of times we think wait a minute, this happened, that happened. I experienced this terrible thing. The landlord is allowed to challenge that. You've got to produce evidence of it. Okay, Exhibit 114, proof of violation of tenant harassment, if that is applicable. 115, utility payments. Sometimes those get asked, and sometimes those can be helpful. Especially if like the gas company comes and cites the landlord for something and you have evidence of that in the utilities portion. Third-party inspection reports if applicable. So you're not necessarily going to have evidence in all of these. You may only have evidence in a few of them, but the way this is written is if applicable for all of them. So either it is here or it isn't. This is what I'm giving you as evidence. This is what I have. And remember what it says at the top. I will produce all documents, evidence in my possession, custody, or control. Okay, it's important to remember that that's what you're expected to do. And this last line covers you for anything you might have requested. For example, maybe you're waiting for a report from LAHD, you're waiting for some document from an employer that supports your COVID impact, whatever it might be that could be outstanding, that at the time the discovery is due, you don't have yet. This is letting the other side know that you potentially have other documents that you're waiting for, and that you have the right to supplement your exhibits at a later time. And all the answers to these are the same. Every answer to every one of them, no matter what the request is up here, you're going to put this in as your response, because you're going to put all your evidence into exhibits, and that's your response. You might change some of the exhibits, add some, remove some. Sometimes people prefer to remove ones where they don't have any evidence, but you can leave it in because it says if applicable, right? You can add to it. Like say something you want to add as evidence isn't included here. You think it belongs in its own category. We think we've been pretty thorough up here, but you could have something that is outside of this and you want to put that evidence in. You can create additional exhibits. And then you would just make sure that when you copy and paste, you write out all the exhibits you have in your binder and then copy and paste to the others. Now, unlike special interrogatories and unlike the request for admissions, which have a limit of 35, sadly, for request for production of documents, they have unlimited requests. They can ask you to produce whatever they want. And usually, the block firm will ask for standard number, reasonable number. Other firms will ask, I've seen some firms ask for over 100 different requests, and they're often repetitive. And they don't have to put a affidavit explaining why. They're allowed to ask for unlimited. But no matter how many they put in, you're going to put in the same paragraph. because your exhibits are your exhibits, and they are covered here in your binder. All the exhibits you have that you're required to produce, you put into your binder, into categories, chronological order. And when you're done, right, you don't have to put in, these have the questions, okay? These are the block questions, and I put them in for this. But you don't have to put in the question for production of documents. You should put the question in for special interrogatories. You should put the question in for requests for admission. It's only the production of documents where it's not necessary to put in the question that they've asked. You just need to put in the response. But you should put in as many responses as they've asked. If they put over 40, I think we have like a, let me go to the bottom. I know this one doesn't have it. This is just based on a block discovery, so it ends at 23. But in the template that I gave you, I think it says like, it goes up to 40, and then anything over 40, it says 42, and you put in the number. So it might say production of document request 41-2 and blank, you write in the last number of whatever request they've given, and it's still going to have the same paragraph. It's basically saying, no matter what your question is, look to my exhibit binder. That's where you're going to find all the exhibits. That's what I have to give you. No matter what your question is, this is the evidence I have. Okay? And you should take into consideration the questions to prompt you to put in the evidence, but that response is saying, whatever your question is, this is where you'll find the answer in these categories. And once again, at the end, you're going to date it based on the date of service, not the date that you finish your binder, the date that you serve your exhibit binder with your responses. And you sign it and date it on the same day. You do the verification pages. Very important. Don't just sign up here and think you're done. This is, if you don't sign this page, the verification, it's as if you didn't respond at all.
Ted? Okay. You have prior experience?
Sworn. Check that. Okay, apologize for that interruption. So make sure you sign the verification page. You put in, this is for the individual that's responding, the responding party. And they sign here. The date here should match the date of service. This should be your location. If I was sending this, I live in Cathedral City. I would have to put in Cathedral City, California here. If you live in Los Angeles County, including Los Angeles City, you put Los Angeles. Okay, this verification page, again, is for anyone who doesn't speak English that had to have the requests and the responses translated to them. They must sign that they had the requests translated to them. And the date of service is here, signed here. And then at the end, proof of service. Person needs to be 18 or over, not party of the action, family member, friend, someone who lives in the unit that's not named in the complaint, anyone who's not party to the action. Put their address in here. It says business address because this is the business, this is written from, someone like myself, an EDN employee. But if it's not an EDN employee, it shouldn't say business address, it would say home address and their address here. This should be the date of service. Here, you're putting in the address, the name and address of the firm that served the request. And here you're putting the email addresses of all the people you can find. We often have more than what is given to you. Very often at the top left of the discovery request, it'll have the address, of the firm and their email address. But we often have additional email addresses for some of the attorneys at that firm. So you can contact us to get more email addresses. You can always ask me for them. I will try to get them for you, so that you have more people that you can send it to from that firm so that they can't say they didn't get it. And they don't often say that they didn't receive it. It's very rare, but every once in a while it happens. Mostly it's an oversight on their part. They didn't check. They just assume. And then we show them that they're wrong. Very often we'll contact them directly and say, hey, we're the ones, EDN served them, and this is the date, please check. And they'll check and say, oh, okay, we're sorry, we made a mistake, and they'll take the motion to compel off the calendar. Okay. At the bottom is the date of service and signature of the person who served. This is the person who's not party of the action. 18 or over, not party of the action. And that's the end. And so hopefully you're all working on your binders, getting all your exhibits in order. Remember, discovery is all the evidence, whether it's relevant to your defenses or not. And when you're making your trial binder, that's focused on the actual evidence you would produce to support the defenses you raised in your answer. The discovery portion is larger, more exhibits typically, because they are not always relevant to the defenses, but you must produce all communication between parties, all. It's always all, so that's what you got to produce. It's time consuming to make the binder, but the response is very simple. They're already in there for you. You just got to make sure that all you have to do is make sure that the last one, the last number, matches the number of requests that were given to you. If they requested, 25, you're going to make sure that you've put 25 responses, and they're all the same, but just each one is numbered. They're all going to look like the first one, which has the new information. The template I gave you has this first response. It's already there. This response is in all of them. It's already done for you. It doesn't have any question in it. It just says 1, 2, and it has this done for you. The only thing you'll have to do potentially is remove or add, whichever is the case, based on the number of production of document requests you were given. That's all you have to do in terms of the response template. And also obviously the signatures and dating and all that. But the exhibit binder is time consuming. It takes time to gather all the evidence, put it in the binder, chronological order. That takes time. Get started. Don't wait till the last minute. Remember, they can potentially file motions in limine to exclude any evidence not disclosed during discovery, because discovery is asking for everything, and you must give everything, good, bad, and ugly. And so you want to make sure you do that, because potentially what people tend to think they can do, and they're wrong, is save something as a surprise. I'm going to surprise the landlord with this evidence. I'm not going to disclose it in discovery. I'm just going to save it for the trial so they don't have any time to prepare for it. That's my strategy. Well, that's a bad strategy, because that will be inadmissible because you didn't disclose it during discovery. All evidence must be shared. When we have the meet and confer deadline, you probably have, if you've been in How to Be a Tech Pro, you know the meet and confer is the share of trial binders with the other side. Any evidence you intend to use in trial must be included. Same with them. They have to do the same. They have to share with you their evidence. You get to see their case. They get to see your case. They could see your case and be so intimidated by all the evidence you have that they dismiss the case. They try to solve it some other way. They may try to settle with you to pay and stay, or give you a really generous move-out agreement. You never know, right? You want to make it as intimidating as possible. I showed up at court, my first appearance, with a massive stack of evidence. And I got exactly what I wanted. And I think that played into it. So think about it that way. Think of your discovery as being your opportunity to make your case with evidence. You're putting in all the evidence that makes your case, the defenses that you raised. The landlord can't evict me because I have all this evidence. And that's what you should all be trying to do. It's a lot of work. You got to be committed you got to come to the classes and figure out how to do it right. I'm here for you as a resource. Tuesdays at 12 o'clock, Thursdays at 12 o'clock. You can also come to my office hours. And now I'm going to open up the floor to questions, but I'm going to stop the video here. Hold on a second.